Welcome to the docket presented by Defense Stars. We're going to give you just facts on our continuing coverage of the Delphi case. What's up, y'all? Good little crowd, 416 so far. Excited about that. I'm also excited to introduce my brilliant, beautiful co-host, best damn lawyer I know, Ali Mata. What's up, girl?
Hi.
Hi. All right, so yet another huge day in the land of Delphi. As you're aware, I drove to St. Louis last night for something non-Delphi related. I knew that this was coming down today. It was very hard for me to keep my mouth shut. You're always saying that I have a mouth and I can't keep a secret. And I knew this was coming down today. Sleuthy and I both knew. We had been working with Kara to give her everything that we could in terms of what we knew. And we knew it was coming down. So I pat myself on the back because I do perpetually have a big mouth. So that was a tough secret to keep. But I was relieved to see because Kara was texting me in the morning and she's like, we're at the court. We're hoping they're going to approve the filing. She's like, I'm so nervous. And then because I had told her, I'm like, as soon as you file it, email it to me so that I could break the news. So I could be the first person before people get off the docket. However, I was in St. Louis. I was doing a prison visit for a guy named Christopher Vaughn. You may or may not have heard of that case. I'm going to be getting involved with that. We believe that there potentially is a wrongful conviction there. So I had a prison visit with him, and the timing of that could not have been any worse for me in terms of this going down today. Like Sleuthy's like, she's like, I've got the document. I'm like, it's like, why haven't you posted anything? I'm like, because I had picked up the appellate lawyer, from his hotel, and then we took the drive to Pinckneyville to go to the prison thing. So it was a rough day. So I was trying to, I desperately wanted to do a live this morning, but it didn't work out. So here we are right now. So huge day. If you're gainfully employed and you are not aware of what happened today, or if you have other things going on in your life and you're not obsessed with this case like I am, you're not aware of what went on in this case.
Well, even when you are obsessed with this case, sometimes you're not aware when things happen in the same day.
That's true. 100%, because it's coming at a million miles an hour with this thing. So today, a couple of lawyers that I really, really respect the hell out of, Kara Winnicke, who I'm super excited. I'm just going to throw it out there right now. She is coming on Wednesday night to Just Facts. She's going to be joining us. I could not be more excited to have her. And we'll be digging into all that stuff. So mark your calendars. That is going down on this Wednesday. I'll, of course, post a thumbnail and put it in the socials, but just plan on being here for that. And then Mark Lehman from the Lehman Law Office joined in with her to get this thing done in a weekend's time. Like the amount of work that goes into this, because it's not just factual when you're putting something together like this. It's the law. You have to research the law. The law is what is going to give either the Supreme Court of Indiana the gumption and the ammo to say, yes, we're going to grant this extreme remedy, or to say, no, we're not going to grant it. So that law is critical. Like this just isn't like arguing like people argue about factual things. You need precedent. You need to be able to show why they're right. And that's why people cite case law in terms of when you're looking at filings like this. So, but again, so we had a new original action, okay, for a petition for a writ of mandamus. And essentially it's a brand new action. So it's got a different case number than the previous writ, which is still pending. As we know, Gull hired an attorney for that. I got a message today. I have not been able to substantiate it, but it sounds like she's hired 2 different attorneys to handle this, because that one was collateral. That was not dealing with the
Yeah,
case.
so let me explain to them why it's 2 different matters. Because, like your typical case, be it, well, in your typical case, if there's like something new you need to add, you'd file like an amended pleading or supplement your pleading, just add it in there. But I am by no means an expert in mandamuses. I don't even know if it's mandamus. I'm just kidding. But
Mandami.
mandami. But it's like a whole different relief that is sought in this new petition, which is my understanding of why it's a completely new, like Bob called it, a new original action. Because in the first, they were asking, amongst other things, but like that the court make the docket look the way it's supposed to, and that the Supreme Court compel the judge to docket the things that were supposed to be docketed, and that kind of thing. And here they're specifically asking, well, I don't want to, for different relief. I mean, I don't know if you want to tell them ahead of time what relief they're looking for.
Always trying to give the spoilers. Yeah, let's hold off, because and just so you guys understand, Allison and I have raging wars before these lives about me reading. I like to read. I've seen enough people out there saying that you like when I read it to you. I think it's important. We're not just here talking about stuff like there's many other great channels out there who I adore that aren't necessarily attorneys. We bring something a little bit different to the table, and I think it benefits our viewers for us to read it, and to go through it. And it's not that lengthy. I know 21 pages sounds like a lot, but you've got a table of contents, you've got the caption, you've got the verification. So you could take 4 or 5 pages and strip it right off. We're down to like, what, 16 pages? I'm good for it. You know what I mean? Like, and I like reading it. Like, people that like my podcast, our podcast, like that I read things. I always read PCAs. I like reading things, and I like explaining it that's what we're bringing to the table. Otherwise, I'm just a big mouth that never shuts up. So like, I have to read it, babe. I'm sorry. I hope you'll forgive me. All right. So I want to bring it up, and I had somebody mention, I'm going to pull off the lower banner, I think. Because I had somebody mention that they thought that it was hard when we put up a document, which made sense to me. So I want to accommodate people, because I do want people to be able to see the document and view it for themselves.
Why else are you putting it up there, right?
Exactly. It's not just eye candy. So, all right, let me bring this bad boy up. Okay. I'm getting like somewhat proficient. All right. I wouldn't say I'm crushing the game, but I'm getting somewhat proficient. All right. So here you go. Indiana Supreme Court. We got the relator's brief in support of the petition for the writ of mandamus. And just for the record, everyone, I asked Allie beforehand if she would like to read some, and she declined. I don't want people thinking I'm trying to bogart everything, because I'm not.
Stop
I love
bogarting everything.
Well, people are like, why don't you shut up and let her talk? I'm like, I wish she'd talk all the time. Believe me, I get sick of talking, believe it or not.
No, you are the much better voice for reading, in that alone is a good reason.
I think you have an amazing voice. So,
well, thank you, sir.
I reject that premise, but I appreciate that. All right, so we'll go through the table content. You know what? We don't even need to. So, like, table contents, we're going to read
the summary.
Should I give them the summary?
Yeah,
where?
Sure.
No,
I don't think
the introduction. Yeah, that's
I meant the table of contents gives them a little.
Oh, okay. All right. I feel you. All right. So intro, background, and then you've got their arguments. So they're going to make various arguments, and they're going to lay them out for us here. So IA is Rick requested and was appointed competent and experienced counsel. IB, Rick's lawyers issued a press release affirming Rick's innocence. IC, due to his declining mental and physical health, Rick asked to be moved out of the maximum security segregation confinement. ID. Rick and his attorneys formulated a strategy of seeking a speedy trial and pursuing a defense of third-party guilt, i.e., the trial court removed Rick's chosen counsel over his objection. And then IF, to continue pursuing Rick's trial strategy, counsel remained in the case as private counsel, but the court DQ'd them anyway. All
And I just want to pop in right here, even though it's like not a legal issue or whatever. I just would have preferred if they called him Mr. Allen.
So it's funny that you said that. I was talking to Kara on the drive home. Why do we typically want to use somebody's name?
Well, to personalize them, but I feel like using Mr. Allen instead of the defense. I don't know. When you're talking to the Supreme Court, and she's obviously, I'm assuming these are lawyers that are often in front of the Supreme Court. So, you know, they know what they want it to sound like and feel like. I just thought, I mean, not even like Richard. It's not even like Richard. It's Rick.
So, right. And like, we literally had this literal conversation, and she said that they discussed it for like hours, like how to address them. And, you know, they ended, they're like, we want to humanize him. We're like, he's always Richard Allen in all the pleadings. They wanted to try to pull him out of being the guy in the pleadings and the PCA and the guy that's accused of murder and try to humanize him. So that's why they went with Rick, which is what he goes by. It's what his wife calls. Kathy calls him Rick. So
I figured that was his name.
Yeah. Like, I mean, it would be like if you were writing the pleading on my behalf, even though my birth name is Robert, I'd want you to call me Bob, because that's what I go by, you know, little Bobby. You could even call me Bobby.
I'm going to call you that, little Bobby.
Little Bobby Mata. You could put it a little Bobby Mata. All right. So the grounds for the writ.
Wasn't that Murdoch? Something like that.
It was something like that. It was something like that. Grounds for writs of mandamus and prohibition. Okay. And this is the trial court lacked any authority to remove Rick's entire defense team over his objection and based on a summary finding of gross negligence.
And I'm going to chime in again to be super annoying and chime in.
Baby.
So I researched this whole gross negligence, and I searched in all of Indiana, in all the Seventh Circuit. So that's the federal circuit that Indiana falls in. And then the entire federal case law in existence. Gross negligence come up in the same paragraph or even 250 words of removing or disqualifying counsel, attorney, or lawyer. So
explain that to lay people that have never been on Westlaw in their entire lives. They don't have
I'm just saying that the question was, is even a finding of gross negligence like some sort of standard that allows the court to, you know, to remove a lawyer for what if they make this gross negligence finding. And albeit I didn't spend as much time as I would have liked, but a quick, you know, review of the law didn't seem like gross negligence was ever a term discussed in cases, in federal cases or in Indiana in relation to the removal or disqualification of a lawyer.
Okay, so that's excellent information. Did you find any case law to where a judge can make a finding of any kind without an evidentiary hearing of any kind?
I didn't look for that because you need due process dictates that you have notice and an opportunity to be heard, which you will, you know, hear throughout this, the same thing that you've been telling people, you know, for the last several lives.
Yes. You know, and I had some static from the other side. Some of my prosecutor friends apparently disagreed with me about the whole due process thing, but we need due process in this country. It's mandatory. All right. So let's get in. All right. So I'm going to go in the introduction. There are certain words that really, really piss YouTube off that I will not say. And if you guys notice in the chats that a comment that you may have typed not coming through, I'm not trying to get demonetized a month into our YouTube channel. So if I don't say a word that and you can read along with me. So if I don't say a word, that's because it's on YouTube's hit list for, if you say that word, we're gonna pull your ticket. Okay. So
Or hence
just a
things
warning
like unalived.
right. Like everyone like takes great umbrage to when people use that word, but they use it for a reason. So they're not getting demonetized on YouTube or whatever, Facebook, any of them. All right. Introduction. Over 5 years after teens Abigail Williams and Liberty German were brutally beep in Delphi, police announced that they had arrested Richard Rick Allen. They called him Richard. See, you're good. For the beep, concluding a police investigation that had captured the whole world's attention and involved thousands of tips. At his initial hearing and clad in protective gear for his own safety, Rick told the court that he would be hiring private counsel, which is a true story. Rick was transported to the DOC for safekeeping. The judge removed himself from the case. That's Judge Diener, and who happened to, by the way, be the judge who issued the very warrant that they're attacking in the Franks hearing. And he also signed off on the arrest warrant, search warrant and arrest warrant. And a special judge was appointed, that being Francis Gull. But a week later, Rick threw himself at the mercy of the court, which he actually said in a letter. I'm throwing myself at the mercy of the court. I remember when that letter came out, I told Allison, I'm like, this poor guy, it's like, he doesn't have to throw himself at the mercy of the court. He's by law, he gets a public defender if he's indigent. He didn't know. He doesn't know. So like many defendants don't realize their rights, which is why you need defense attorneys. So, and he requested a public defender, Andrew Baldwin and Brad Rozzi. Rozzi, Jesus. For as many times as I've said that guy's name, you'd think
whenever it's in print, it's going to happen.
It's because that's how you pronounce it. I'm Italian, for God's sakes. Attorneys with a combined 50 years of experience were appointed. Over the next year, Baldwin and Rozzi zealously advocated on Rick's behalf. They appropriately asserted Rick's innocence after the public release of the probable cause affidavit. Now, they've once again included the record. They've added some more stuff, which I'm saving for our live with Kara and Sleuthy, okay? Because they're both coming on with us. Like, they have the transcript from the last hearing where McClellan decided that he also found them to be grossly not good. Like, again, without the benefit of a hearing, Nick McClellan found Rozzi and Baldwin also to be grossly negligent. But there's some interesting things in there.
Baldwin and Rozzi found him to be an unscrupulous liar. So
right, exactly.
I mean,
I'm gonna tell Baldwin you called him Baldy. Just so he knows, just so that's out there. Okay. Okay. So over the next year, Baldwin and Rozzi zealously advocated on Rick's behalf. They appropriately asserted Rick's innocence after the public release of the probable cause affidavit. They repeatedly requested a change in the conditions of his confinement due to the obvious effect the conditions were having on his physical and mental health. And they prepared a trial strategy with Rick pouring through thousands of pages of discovery to prepare his defense for a January 2024 trial. Now, I've told you guys, like, I'm there. I'm there for all the hearings. And the first time I laid eyes on Rick in June, I was stunned at what he looked like. I had seen the pictures with the dirty shirt and him looking not normal, but to see him in person really, really took me by surprise. Like I was stunned. Like he had that 1,000-yard square or stare where you just like he looked vacant. He looked like he wasn't there, like mentally at all. And aside from the massive weight loss, it was just, I was like, wow. And then Andy Baldwin at that particular hearing in June had his chair pointed at Richard. Richard was just kind of like sitting there forward, like not moving. like just sitting there like a stone golem. And like that entire hearing, it was almost like Andy was translating to Richard. He was like whispering in his ear what was going on during that hearing in June. And that was the hearing that was supposed to be something else that ended up being the first time that they tried to get him moved from Westville Penitentiary. So like, but I'm not going to start complaining about the docket again, but that thing speaks for itself. Okay. So during that time, Rick never complained to the court about his attorneys. And then they have a citation. I'm not going to read the cites because it makes it longer than it needs to be. On the contrary, he unequivocally stated his desire to have attorneys Baldwin and Rozzi continue their zealous representation. Yet, less than 3 months before trial, the court removed attorneys Baldwin and Rozzi as counsel, citing its extrajudicial finding. Counsel had engaged in gross negligence. Allison, as we've already established, that you are an expert on extrajudicial. What does that mean for people that may not have been on the last live?
Such a jackass. Out of court statement.
Right. Okay. So that's what I kept saying. Like when I was enraged about this, like she kept saying she had a finding. Based on what? You have to have a hearing to have a finding, Your Honor. You can't just find things. I made a finding based on what? Based on a law enforcement agencies or multiple agencies that have a vested interest in Rick Allen being convicted. Yeah, nice. Like this needs an independent investigation if they're going to look into that, the leak and everything that happened subsequent to it. Not by the very same cops who desperately want their work to be acknowledged and to be rewarded because they get a conviction on Rick Allen. You can't have that agency or those agencies investigating what went down there, period. And that's my position on it. If you want to argue about it, bring it. I'm ready for it. At Rick's discretion, attorneys Baldwin and Rozzi entered appearances as private counsel, agreeing to continue to represent him for free. So that is when they entered their pro bono appearances as private counsel. And that was that morning that I was there. I knew that they had entered their appearances because of whatever. And so I knew I was waiting, like the people that we were all in line, they're like, are they going to show up? I'm like, of course they're going to show up. They entered their appearances. They're going to walk right in that courtroom. They're going to kick the front door open and they're going to pull out their guns and say, what's up? None of that happened, except they did walk into court and, they were ready for action, only to be denied. But at a hearing held on October 31st, 2023, the court told Rick that it had grave concerns about his defense team and that he was entitled to a vigorous defense because what these guys were doing wasn't a vigorous defense, Allison. That 136-page memo, which people either love or hate. I don't know that there's an in-between with it. I love it. Some people hate it. I think it's a masterpiece. I don't care what anybody says. I practiced criminal defense law for 20 years. My friends that don't like it didn't. So I'm going to say I win. The thing's like unbelievable. Like that being said, there, like we've discussed, there's some things I would have kept out, obviously. Like I would have kept out, like,
all right.
Like
we know you did say that.
All right. Okay. So, and that the court cannot and will not allow these attorneys to represent you. I can't do it, sir. I just can't. Okay. So when you see those, that R226, that is a cite to the actual transcript, the record. Okay. Whenever you see those in pleadings like that, it's a citation to another document or a transcript or something like that. Rick's trial had been reset or has been reset for a year from now. And he's been forced to start over with his new attorneys, which we'll get into them. Scramming, I don't have much to say about him. I don't know much about him. Labrado, and I don't know if I think I'm butchering his name. There's a story there, and we'll get into it. Not on this live, but we'll get into it. The court statement about Rick's counsel have completely undermined the credibility of Rick's proffered defense. Okay. Rick has an original action currently pending in this court, which is the other writ of mandamus or the petition for the writ of mandamus concerning the lack of public access to the public records in this case. The lack of transparency is an important societal interest, but the issue here implicates Rick's fundamental constitutional rights to counsel in a fair trial. What do you think of that, babe?
Sure does.
Sure does.
I mean,
Show you right. Show you right, Kara. Show you right. All right. So the background. IA, Rick requested and was appointed competent and experienced counsel. And like, I've taken great exception to, oh, you guys get to hear Allison drinking. It's amazing.
oh, sorry.
When she's working out, when she's got the Oculus on and she's like pouring sweat because she's vigorously working out, she'll slam those little ball jars of ice water. It's a sight to behold. But I digress.
I'm glad. They're so glad they got all that.
I mean, there's nothing more adorable than you doing the Oculus, though. I'm just going to say one day I'm going to sneak photos or video.
No, you are not.
So cute, though. All right. On October 28, 2022, the state charged Rick with 2 counts of murder. Officers arrested Rick and took him into custody, where he has remained ever since. The Carroll County Circuit Court ordered Rick transported to the DOC, which is Department of Corrections, for safekeeping. As we've said many times, typically pretrial detainees are housed in the county jail, not the Department of Corrections. That's where convicted people go, felons typically. You know, Westville Penitentiary is the house of pain in Indiana. It's where the worst of the worst go. That's where Rick is pretrial for his own safekeeping.
I mean, he's got to be kept safe.
He's got to be kept safe, you know, due to a toxic and harmful insistence on public information from media about the case. After sending Rick to the DOC, the judge recused himself. So that was the Honorable Judge Diener that did that. Then the Honorable Francis C. Gull accepted appointment as special judge. Now, tell people special does not mean that they think she's really awesome and you're a special person. What does special judge mean? Like, why do they have special judges appointed to cases typically?
For that type of situation where the judges in that county are conflicted out or there's some sort of issue. Same thing they do, like if there's a special prosecutor, it means they, for whatever reason, there was a conflict, the appearance of impropriety, whatever the case may be, and they want to bring somebody who's not typically in that county or doing that role in that county on board.
Right. And so they brought her in and she sits on the bench in Allen County. So Rick requested a public defender to represent him. Attorneys Andrew Baldwin and Brad Rozzi were appointed as Rick's counsels. Attorney Baldwin is one of only 4 Indiana attorneys certified as a criminal trial specialist by the National Board of Trial Advocacy, as authorized under Indiana Rule of Professional Conduct 7.4. He has nearly 30 years of criminal trial experience, handling hundreds of jury trials and representing numerous defendants charged with murder. Attorney Baldwin has never been disciplined or suspended. That all matters. That gives you the background on the people that were casting shade and like it was really, really upsetting me when people were talking trash about these people that they have no idea who they are. They have no idea what their careers are about. And they're basically going on one side of the story. You know, that's why you need hearings. That's why hearings matter. That's why due process matters. So Attorney Rozzi, what's he been up to? What's he been doing over his career? So he has 20 years of criminal trial experience, handling thousands of cases, including 8 murder cases, which, if I'm correct, the prosecutors never tried a murder case. I think it's a little known fact. Attorney Rozzi practices regularly in Carroll County and surrounding counties. He was born and raised in adjoining Cass County, and is intimately familiar with the police officers and prosecutors investigating and prosecuting this case. Attorney Rozzi has never been disciplined or suspended. Rick wants this partnership to handle his defense. As a matter of fact, I believe that Brad Rozzi's brother is Indiana State Police. IB, Rick's lawyers issued a press release affirming Rick's innocence. This press release I loved. I loved it more than anything that I love ever, aside from you, of course, and my kids and the dog.
And tons of other things, but go on.
No, but so on November 29th, the charging information and probable cause affidavit in Rick's case were made available to the public. Now, if you guys don't remember this was like after she unsealed the PCA, she being Gull, because remember, he was arrested, she had sealed the PCA. And I'm like, why is she sealing this? You don't seal PCAs unless somebody's going to die. You know, so it's got to be something extremely, extremely volatile.
Post-arrest, that is.
Yeah, right. Exactly. Post-arrest. So she seals it. And after she unseals it, I read it and I'm like, why was this sealed? What did you say when you saw it?
There was nothing worthy of sealing. It was basically nothing in it at all.
So you said, why was this sealed?
I'm sure I did.
That's exactly what you said. You know, so which is very rare in this world. These guys issued a press release, which I'm going to pull up on our next live with Kara and Sleuthy because I love it. And this was basically them offsetting the PCA. Now, people take exception with the memo because they put their trial strategy out there. Well, what do you think a PCA is? The PCA is the state's case in chief right there for you. Sure, they'll have evidence that they gather after arrest. They're not keeping out any smoking gun evidence out of the PCA. I'm going to say that over and over and over until you actually believe me, because it's true. Now, that doesn't mean that they're not going to get smoking gun evidence after the arrest, which, of course, could not be included in the PCA because they didn't find it until after the PCA was written. Does that make sense? So, like, as far as these guys putting this thing out, it was he's innocent. And this is why. It was unbelievable. I don't even know if you remember it. I loved it. I don't know if I did a spaces on that. It was one of those things where I was reading like a crazy person, like all excited, because this just never happens. It's always the state puts out their case, the press tries the defendants for 3 years while we pen trial, and then you've got to try to go in there as a defense attorney and try to find one juror that isn't poisoned. It's very hard. So this was an evening of the play. Like, it evens the playing field. Like, I had no problem with this. I loved that they did it. Which responded to the allegations contained in the affidavit. Reasserted Rick's innocence and indicated that they would continue to share exculpatory information with the public to the extent that they were ethically permitted to do so. Later that day, the court entered a gag order prohibiting the parties from making extrajudicial statements about the case, which was reaffirmed after a hearing. The court also entered a protective order prohibiting parties from divulging or granting access to the discovery material to all but certain people. Now, that becomes the offending order, the protective order, where the leak led to all of this. Okay. It's that protective order. The protective order is different from a gag order. A gag order is different from a sealing order. They're all different things. Okay. So on December 21st, 2022, Rick's counsel, Andrew Baldwin, inadvertently emailed a summary log of the evidence on a flash drive received during discovery. The log did not contain any substantive evidence, but was similar to the table of contents. Now, this is one of the 4 or 5 points that Gull had on her bullet point list that she handed to Rozzi and Baldwin and Chambers on the 19th and said, here, this is what I'm going to read in open court without the benefit of having a hearing, without due process, and I'm going to flamethrow you for the world to see.
And they did it correctly the first time. I mean, correctly as far as she entered this, either it was the protective order or the gag order. I can't remember which, even though you literally just read it. But she did that without a hearing, without a finding, without anything, and then set it over for a hearing, and then actually entertained the issues and made findings, after the fact.
Right. Yeah. I mean, when it suits her, it makes it into a hearing. She has a hearing.
Right.
She's
puts like, there's this thing I'm supposed to do. So now I'm going to do it.
So I'm going to go ahead and I'm going to put this one on the docket so people can read it. This is my decision because I had a hearing.
The other stuff, not so much. All right. So I see, due to his declining mental and physical health, Rick asked to be moved out of a maximum security segregation confinement. All right. Now, we experienced this with Anthony Garcia, 23 hours a day in solitary. And I'm just telling you, and I'm begging you to believe me. I just met with another guy who pretrial detainee who was in Will County out by us, accused of a horrific crime that involved children. They tortured this guy, the inmates, the guards. It's like, it happens. I wish people would just understand. I feel like I want to take all of you on a tour of a prison. Everyone who naysays it, I want you to send me a DM, and I'm going to rent the biggest bus in the history of buses. I'm going to bring you all to a house of pain so we could spend a day in there. And of course, the guards are on their best behavior then. This is all under cover of darkness, when they keep the lights on, when they I'm going to tell you one of the Christopher Vaughn stories that he told me, like what some of the things that they were doing to him. But it was the same thing that they were doing to Garcia, just psychological warfare, just absolutely psychological warfare. All right. So Rick was to be moved, or they wanted to modify the safekeeping order, arguing that he was unrepresented when the order was entered, which is true, and that no hearing had ever been held on that motion, which was true, and that he was being held in a maximum security segregation unit at Westville that is generally reserved for violent convicted offenders, and that the WCF had a history, and that's Westville Correctional Facility, had a history of unequal and inhumane treatment of its inmates. Rick described the conditions in which he was being held, as well as the obvious decline in his physical and mental health. Rick explained the significant hardship his placement at WCF had on his ability to assist his attorneys in preparing his defense. Now, explain that to people, Allie. Like, why, like when they're talking about the ability to assist your attorneys in preparing your defense, what does that trigger if you can't do it? You're muted.
I was muted because of that whole water drinking, thing.
We all love it.
But you're right to a fair trial is implicated there. And it's like the less access they have to their client, the less ability they are to exchange documents with their client, those kind of things makes it harder for him to assist in his own defense. And that's often something we use to try and get somebody out of jail pre-trial so that they can be, in their house and on the street trying to get records or, hunt down witnesses, whatever the case may be. But for these purposes, it's more dealing with their access to him, their ability to get him documents, exchange documents, talk to him as quickly as they might otherwise do.
And competency. Like if you're right.
If they're talking about that, his ability to assist in his own defense because he's deteriorating mentally because of all the things you spoke of before, well then, that's obviously a huge issue. Yeah.
All right. So the court denied the motion, reaffirmed its prior order, and clarified that the DOC could move Rick to accommodate his needs. Attorney Rozzi filed a tort claim. Okay. Notice preserve Rick's right to obtain private counsel in the future to file a civil suit relating to the conditions of his DOC. See, these are the little things that Rozzi was doing just to stick it right in Gull's keister. It's like she denies that motion, and he felt adamantly, as we did with Garcia. We were enraged that they wouldn't take him out of segregation. We're like, why do you have this guy in segregation? What are you doing? And their rationale for him, he was accused of killing a child as well. They hated him. They don't, like I've said, they don't care about the presumption of innocence in a jail or a prison. That's not something that exists in those walls. So, and their excuse for Garcia was that he had worked as a doctor in a prison. So he was an escape risk because he knew the inner workings of the prison, how he could escape. So that was their rationale for 3 years to keep our client in 23-hour segregation by himself every day.
And that was of the general prisons because it wasn't that.
That was just Douglas County Jail. That wasn't even.
What I'm saying is that he never worked in that specific jail. So it's not like.
Right. And he watched Shawshank. And, we all saw how Andy got out. So I think
it's
that
definitely a
was
roadmap.
another rationale that if you've watched Shawshank, we have to keep you in
23 hours.
segregation because you know how to escape from a prison, and you crawl through 500 yards of shit and come out clean on the other side. All right, ID. Rick and his attorneys formulated a strategy of seeking a speedy trial and pursuing a defense of third-party guilt. This is the memo. 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 Can you name that movie, babe? I don't think you can. Somebody out there, someone in the chat, tell me if somebody gets that. I'm sending you.
Bueller? Are you talking about Ferris Bueller? Bueller? What are you doing?
Wrong.
All right, just move on, sir.
I am. Rick's counsel continued to file motions to change his confinement conditions. He and his attorneys also developed a trial strategy of seeking a speedy trial. This is so good. This is the one thing I didn't know. This is the one avenue that I didn't know. So he and his attorneys also developed a trial strategy of seeking a speedy trial and pursuing a defense of third-party guilt. Obviously, we knew about the third-party guilt. Speedy trial, not so much. I did not know all of this coming up about the speedy trial demand. It's so, when Kara told me about it, like she had written me like a text of like a thing that they were doing in here. I was like, oh, that's so good. In terms of a motivation of why Gull really wanted these guys off the case.
And also a motivation for having more of a reason to leave them on.
Well, if she cared about justice for the girls, you know, if she cared about prompt justice for the girls, like, I mean, finding this out about Judge Gull, if I'm the family members, whether they think Rick Allen's guilty or not, and whether they think that he's the right guy or not, the fact of the matter is this thing is going to trial. And for the families of the victims, I'd be extremely upset to know that the defense counsel had every intention on going to trial on January 8th. They were making the demand. They were putting it to McClelland. We're ready. Are you ready? You ready, Nikki? Because we're going to trial January 8th. Be ready, because we're ready. Even though you're slow playing discovery to us, we're ready. I'm telling y'all, this is what fighting for a guy that you believe innocent looks like.
Was that Office Space? Somebody threw it out there. It seemed like a possible correct answer.
Memo. It's like you're going to have to be as old as me. The only clue I'm going to give, no, I'm not going to give a clue because it'll give it away. It's like it's a machine that was in the scene. Somebody's got to get it. All right, I'm going to up it to 2 stickers, but don't cheat and Google it. I'm going to know if you do.
Yeah.
Okay.
Big Brother's
several months before trial, Rick filed motions to suppress evidence. A motion in limine regarding the ballistics evidence, which I never saw on the docket. Explain to the people what a motion in limine is, honey.
And I thought we might have seen that. Well, I think what we saw was, so in maybe
Indiana, I did see that. Maybe I did.
In Indiana, clearly what they do is like these very basic motions where you don't put anything in there. You just say like what you're looking for, and then you file the supporting memorandum, and those were always sealed. So we never knew what the basis was, what the grounds were, things like that. And a motion in limine is a motion asking the judge to decide something beforehand to either let evidence in or exclude evidence or things of that nature, but to make the ruling before trial so that they already know going into trial that something's going to be allowed or not allowed.
So if you always wondered when you hear lawyers say motion eliminate, now you know. All right. So they had also made a request for a hearing under Franks v. Delaware, which we all know about the Franks hearing. I'm not going to have you explain what it is. Rick also signed a motion for a speedy trial. Explain to people what a speedy trial demand is.
Well, when you demand a speedy trial, depending on the state, they have a certain number of days to send you to trial. Could be 90 days. If you're in custody, the time is shorter. If you're out, it's longer.
which makes sense. I mean,
Right.
like typically when you've got the client that after reviewing discovery appears more likely than not to be guilty, they're in no rush to get to trial. So now, like, you got a guy like Rick here, who his attorneys wholeheartedly believe he's innocent. They're ready to go. And like, I want to talk about the pressure of the speedy trial demand. It's like it was a big issue in the Idaho 4 case. The whole question of whether or not he was going to waive it. I knew there was no way that Ann Taylor was going to be ready to go to trial on that. No way. This case,
Is Ann Taylor the prosecutor or the defense attorney?
Defense attorney. Like, I knew she wasn't going to be ready. I thought in that one the state would be more ready than she would have been, just because of they had the benefit of having a much bigger office and much more staff working on it. Like, I think that's an all hands on deck case. I mean, Carroll County's small. They just brought on this attorney, the state's attorney named Luttrell, to help McClelland. And Hennessy, when I was sitting next to him in court, David Hennessy was saying, look, like, Luttrell's above board. Like, I mean, he's going to help him, because I think Nick was feeling it. I think he was starting to feel the sphincter squeeze, his trial. Because I try to explain to people 2 months as you're barreling towards trial goes in the blink of an eye. It's like,
I mean, I've got a federal trial. They said arrest was, what month are we in? Was in October. And just 2 days ago, they set trial for the first week of January. And I was like, no, I am
That's
definitely
outrageous.
not going to be ready between Thanksgiving, Christmas, and everything else.
What about us? What about our holiday? What about our life? Don't we get a life? What kind of judge sets something for the first week of January for trial? It's like a torture move. All right, so Rick's attorneys informed the court that they were ready to proceed to trial. Oh, wait, no, I want to read this entire thing over. So Rick also signed a motion for speedy trial, which Rick's attorney planned to file in early November to lock in the January trial date. Now, that is the defendant's right to a speedy trial. So that means that whether or not McClelland is ready, tough shit. If he's going to say, I'm locking my trial date in, you're going to trial, sucker. And if you don't go to trial, if it does not start on the day that the speedy, that it runs, that it ends, he walks. It's that simple. It's over. So that forces the state. So the state hates speedy trial demands, hates it, abhors it. It's like, just so you have an idea of how the inner workings of real court goes, that's not like court TV or, law and crime or, well, not court TV. Court TV deals with real stuff, but like any of the shows that you watch, like strategically, like Allison, she likes to turn the screws on the prosecutors a little bit, and she'll make speedy demands, but
I made a whole bunch right before we went on
COVID.
Yep.
COVID, for real. Like that was one of our biggest things. We're like, how is COVID and them shutting the courts down? Like the constitutional speedy right still exists. Like they can't, like, what are they going to do with it? Like, that was a very fascinating conversation we had.
Right. Let's move on.
Okay. Yes, ma'am. During a telephone conference with the court in early October 2023, Rick's attorneys informed the court that they were ready to proceed to trial in January. So you have to, like, I was talking to Kara. I'm going to let her tell the story on Wednesday. Like, she's going to tell the story that Brad told her about when they told Gull this. It's good. All right. I.e., the trial court removed Rick's chosen counsel over his objection. In August of 2023, a former employee of Attorney Baldwin's office, Mitchell Westerman, stopped by Baldwin's office to visit. See, the guy didn't even work there anymore. Guy did a pop-in. Hey, man, just thought I'd do a pop-in. And Westerman slipped into a conference room where he found crime scene photos and, by his own admission, secretly photographed some of the discovery material and disseminated it. Attorney Baldwin was not aware Westerman had done this. Obviously, like, anybody that was suggesting that he had done this purposefully was really on my list. Like to besmirch an attorney like that was my whole, holding prosecutors and judges like above and beyond reproach is absurd. Like, I don't know why people think that they can shit on defense attorneys. I ain't having it. Not on my watch.
Right.
And I mean, if they deserve it, they deserve it. Any lawyer does. I don't care what side of the aisle you're on. When counsel learned the material had been disseminated, they disclosed the matter in an email to the court and the state on October 6th. So it was a mea culpa immediately to the judge. The prosecutor Nick responded that he had known about the leak for a day. How's that? They just found out about it. But when they call McClelland, when Brad calls Nick, it's like, hey, man, I got to tell you that we had a leak over here, bro.
Right. So this is my theory on that, is that like the prosecution and the police were worried it came from their end, and they were holding it back and investigating it, and that's why they didn't say anything right away. They wanted to see where it came from. Like, shit, did we screw up?
Yeah, I mean, there's people putting the timelines together of the leakers and the recipients of the leaks and who talked to who. And I don't want to get into it now, but something smelly about it. Something stinks in Delphi still. Okay. Prosecutor responded that he had known about the leak for a day, and the state was investigating the matter. On October 9th, 2023, Westerman told Attorney Baldwin about his inappropriate, if not criminal, conduct in secretly photographing the discovery items. So Westerman doesn't tell Baldwin Andy until the 9th. Rick's counsel informed the state and the court the following day, that being Baldwin and Rozzi told the court on the 10th. The parties had a telephone conference with the court that day to discuss the matter, and the state mentioned the issue of disqualifying counsel, mentioned it. So Nick says, oh, man, I think I'm going to have to DQ you suckers. So, look for that. Look for that motion. I'm going to file it, except it never got filed. It's that whole due process thing I keep bitching about. Telling somebody that you're going to do something and then actually doing it are two completely different things. I tell that to Allison all the time. Talking about doing it and doing it are two separate things. A day later, counsel informed Rick of the matter, and Rick immediately and unequivocally indicated he still wanted his attorneys to represent him, believing the representation was in his best interest. And that's in quotes. This letter was filed with the court on October 12th, 2023, as an attachment to the letter filed by Attorney Rozzi. After receiving Rick's letter, the court notified the parties that it was scheduling a hearing on October 19th, 2023, to address other matters. And this is a quote from her order. This is what the people on the other side of this argument were calling notice, proper notice, and saying that he had hired a lawyer, so they had to know. It's not how notice works, friends. It's not how notice. This isn't a free-for-all. The law is built on rules. The entire thing is rules. Every book you have is a bunch of rules. There's nothing that has more rules than the law. So just saying other matters which have recently arisen is not notice that we're having a hearing to DQ your asses. Just isn't, under any circumstances. Like, they don't have to be morons to know when McClelland has said in a conversation, I'm going to DQ you, or I'm going to file a motion to DQ you, that, well, gee, maybe we should get some counsel. Let's call David Hennessy, who's like a baller up in Indy, and let's get him involved with this, see what he has to say about it. So that's not notice, folks. So at that point, she then orders Rick's counsel to, quote, cease work on Mr. Allen's case until after we meet on the 19th. So again, that's not notice. Her threatening and telling them to quit working on his case. It's not a where there's smoke, there's fire situation in the law. You have to give notice. They have to have the opportunity to prepare a defense to it, and there has to be an evidentiary hearing. That is how it works in the law. On Rick's request, the court ordered the attorneys to appear in chambers at 12:30 p.m. before the hearing to discuss what was expected at the hearing. Attorney Baldwin filed a memorandum regarding, quote, possible disqualification or sanctions. And that's what Hennessy wrote it. That's what it was entitled. Possible like we think maybe you're doing this even though no one's filed anything, including the judge going sua sponte, which just means on her own motion. None of that occurred. Okay. So as a prophylactic measure, they drafted this document. Okay. And explaining the circumstances regarding the theft of the discovery, the law regarding a criminal defendant's constitutional right to counsel, the court's limited authority to remove appointed counsel, and a proposed sanction in the event that it was warranted. So that is where he said, yeah, you fine them. I forget what he suggested. They're getting paid by the county for this. And he suggested that they be docked pay. I think it was like a week. Like they would have to work for a week for free. Like that's a sanction, to punish them for being sloppy. On October 19th, 2023, the judge opened the courtroom to the media and for the first time authorized 1 or 2 cameras providing pool coverage to be permitted in the court session. Now, if this doesn't reek to you out there of just an absolute and total, like just setup, like I'm like one and like she doesn't put it in here, but the judge was very careful in her order. If you go back in the docket and read that order pertaining to the cameras, that she states unequivocally that you guys asked for it, meaning Brad and Andy, you guys asked for it. I'm giving it to you. Aren't I nice? Isn't that kind? That's what I'm going to do for you guys. You guys want the cameras? There you go. That's her patting him on the head. Okay. So the attorneys appeared to be in chambers without Rick being present. Huge problem. Like he's the guy whose life is at stake. He is the guy who has to be present when she's DQing his lawyers or coercing them to withdraw. Like the guy, like I never even laid eyes on him. And this was up in Allen County, her home turf. And she moved it into a giant, beautiful courtroom. It's frankly the most beautiful courtroom I'd ever seen, ever. It was gorgeous. During the conference, the trial court read a prepared statement to Rick's counsel. And this is all in camera, back in chambers, accusing them of, quote, gross negligence and citing specific examples of their zealous advocacy as purported acts of their negligence. And these are the purported acts of gross negligence include the following: issuing a press release, which we've just discussed, before the entry of the gag order, filing motions to protect Rick's health and safety, which the court believed lacked evidentiary support, unintentionally emailing a discovery log to a third party, unspecified, quote, improper statements made in the motion to suppress, which I have no idea what that is. Filing a tort claim notice to preserve Rick's right to seek redress for the conditions of his ongoing confinement. Attorney Baldwin hiring a lawyer to appear on his behalf on the issue of sanctions or disqualification. And a third party, they're all absurd.
I know, but when you're, if you're actually being subject to sanctions or disqualifications, it's not unusual to have a lawyer speak on your behalf.
It seems funny that Judge Gull hired lawyers.
Well, she's defending an entire original action.
I mean, these guys are getting DQ'd from like one of the biggest cases in the country.
Right.
Kind of a big deal. A third party impermissibly photographing discovery without the knowledge or consent of either lawyer. The court then informed Rick's attorneys that they had 2 options. Like, and I nailed this when I predict, like, what I, like, before I knew anything, like to a letter, I nailed exactly. Like I was sitting there watching it happen. Like Brad was like running back and forth like a lunatic from chambers to Kathy, back into chambers, back to Kathy, like a man possessed, and you could see it in his eyes that he was just like furious. The court then informed Rick's attorneys that they had 2 options: 1, to voluntarily withdraw their appearances, or 2, be disqualified as counsel after the court reads its prepared statement in open court in front of the cameras. Attorneys Baldwin and Rozzi met with Rick to discuss the matter. Rick disagreed that his trial counsel had engaged in any negligence, and he reaffirmed his desire for them to remain as his counsel. Rick's attorneys informed the court that they believed the court had engaged in an unconstitutional ambush of Rick and his counsel without due process under the law. Counsel also informed the court that they believed their withdrawal was involuntary and done under duress, since their refusal to withdraw would, quote, publicly disparage the representation of the accused, framing their advocacy on his behalf as gross negligence, and cast Rick, his attorneys, and the merits of his defense in a negative light. All true, true, true.
And that's very important because it speaks directly to, all right, the lawyer's not just butthurt. There is truth behind the fact that if you discredit their lawyers, you are, in a sense, discrediting their defense.
Right. Exactly. Which goes right to his right to a fair trial.
Correct.
So, I forget where I was. Okay, such a public statement risks tainting the jury pool, obviously, harming their client's defense, undermining their professional relationship with their client, and possibly creating an actual conflict for their continued representation. Now, what does that mean, Allie? Why would that create an actual conflict?
Because they just shat upon their lawyers. So by them remaining their lawyers, it's shatting upon their defense. So that would create an actual conflict.
Okay. So faced with this dilemma, Attorney Baldwin orally moved to withdraw his appearance, and Rozzi informed the trial court that he would file a formal motion to withdraw his appearance at a later date. Such a baller move. That was such a baller move, man. Like, I loved it. Like,
when 10 of 19, 1 hour.
So what? Do you guys like it? We got 9 pages left. We're we're talking through it. It's like the people like it, hon.
The people like it, hon.
I mean, we've got almost 1,300 people. They must not hate it.
Hi, people that don't hate it.
Okay, so I do want to go back real quick and read this footnote. Where'd the footnote? Did you see the footnote? Where's the footnote?
It's you were just at it. It's almost at the very top.
Oh, okay. So it was a third party impermissibly photographing discovery without their knowledge or consent of the other lawyer. So the footnote is the court reporter declined. So this is classic. And this is like Sleuthy Goosey and I emailed the judge because because David Hennessy told me in court, he's like, hey man, in Indiana, we have a law. The public can request from the judge and or the court reporter and or both that they want to have a viewing of the transcript and or come in and hear the audio. So I told
without charge, they can get the transcript,
or just come in and read it. The public,
well, someone
or listen to the audio, which is what I want. I didn't care about the transcript. I wanted to hear it because you can't tell tone and tenor from a transcript. I wanted to hear if it was heated. I wanted to hear if she sounded like she was threatening them. You know what I'm saying? Like, you can't tell that from a transcript. It's like I'm always telling you, we can't argue in text messages because you can't tell if I'm joking. You can't tell what my tone or tenor is. I'm a sarcastic.
Can't tell if you're joking anyway.
Oh, wow. All right. So the court reporter declined to provide a transcript of the in-chambers proceedings, and the court did not rule on the relator's motion for the transcript. Relator is relying upon the recollection of Rick's attorneys memorialized shortly after the proceeding. Okay, so that's what they've had. Like, she put that footnote in here in case, like, when they actually do get the transcript, if there's any kind of inconsistency, she's saying, look, this is like because you wouldn't give it to us, so we could just put it into the record. Like, my clients, like, in the middle of you DQing them unceremoniously without notice, like, did the best they could to recollect what happened in chambers that day. Okay. All right. So Rozzi did not withdraw. Okay. The judge entered the courtroom, went on the record without Rick or his attorneys present. And like, I sat there, Allie, like in that courtroom, like, Rozzi's not there. He had left with Kathy, and Baldwin's nowhere to be seen. I never laid eyes on Richard Allen the entire day. And she comes into the court. This guy's trial the pretrial hearing without him present in the courtroom, and says the following: that there was an unexpected turn of events and that Rick's lawyers had withdrawn from the case. The court concluded the hearing by noting that the state, quote, had some witnesses here that came earlier to have the hearing, but clearly this is outside of our control.
And I just want to circle back to, correct me if I'm wrong, she never told them what hearing those people were there for.
Right.
So the lawyers were not prepared to go to a hearing, but she had the witnesses show up and told the public we were going to go to a hearing, that no one knew what kind of hearing, but we were going to go to it. And then this unexpected thing that I, of course, knew was going to happen happened.
And it was outside of my control, even though I told
But I did say in that could have passed under some circumstances as the judge just covering so that, the gross negligence of these lawyers was, shielded, or at least that's what she'd try to, I suspect that's how she'll try to rationalize that.
Yeah, but and that's what like the other side saying that she was being kind. That's why I'm saying we need to hear the audio. The audio will tell the whole story. Because her saying, I'm gonna pants you publicly and I'm gonna read all this is not a kindness.
No,
that's not saying I'm cutting you a break. The only way that she cuts them a break is by following the law, giving them notice, allowing for due process to take its course, and having an evidentiary hearing. That's how she does them a favor. That's a judge. That's not them. They can't force the hearing. She has to force it. She made a horrific mistake doing that. That's on her completely. Spare us the kindness, Your Honor, and have your damn hearing. So, because then we're gonna file an interlocutory appeal because you blindsided us with a hearing that you gave us no notice was happening, so that we couldn't prepare for it. Because Hennessy stood up, like I don't know, I think she gets to it. In a written order, the court noted that Rick's pretrial motions were still pending due to the court still reviewing the exhibits submitted by counsel. She's talking about the memo. The woman, as of the end of October, still had not finished the memo. I read that thing in like 2 hours.
Well, in all fairness, she was talking about the 100 and some page, like the extensive exhibits. No, but the exhibits attached to the memo.
She said on the record, and I remember it as clear as day, that she hadn't even finished reading the memo.
I assume that would have meant reviewing all of the exhibits.
Because she said that too. She said that too. She said, I haven't finished reading the memo and I haven't gone through the extremely long list of exhibits. Like she said both things is what I'm trying to tell. I was there. I saw it.
I hear you. Yeah. So
she said
right.
both. Okay. So IF, to continue pursuing Rick's trial strategy, counsel remained in the case as private counsel, but the court DQ'd them. Attorney Rozzi filed a notice indicating that Rick did not want him to withdraw as counsel. This notice informed the court that there was no circumstances under Rule 1.16 of the Indiana Rules of Professional Conduct which warrant the withdrawal of counsel, and that everything cited by the court as alleged gross negligence was the product of ethical lawyering and it's in the best interests of the client's defense and mental and physical well-being. Absolutely true. This is what I've said it now in the last. This is what zealous representation of a client that you believe is innocent looks like. If for one moment, pretend again that Rick Allen's innocent, pretend that you are arrested of a crime that you did not commit. Say it's a homicide. This is how you want your attorneys fighting. Exactly like this, isn't it? Or do you just want them to kind of go through the motions and play nice with the court? You want them fighting like pit bulls, trying to rip the throat of the state out because they're trying to convict an innocent man. That's how you zealously represent your client. That is the job of a defense attorney. We took a sworn oath. We stood in front of a Supreme Court judge of our state and said, we swear that we will, that word is used, zealously represent our clients.
It's in our ethical duties.
It's 100%.
Again, with that word precisely.
Exactly. The notice also indicated that Rick was asserting his constitutional right to the counsel of his choice and wanted counsel to, quote, move forward with the representation of defendant Allen until a disposition of this matter. And he, like, she didn't include it, but he said one way or another is how he actually worded it. I remember that quote from him. Finally, the notice indicated that Rick was prepared to go to trial on January 8th, 2024, and any continuance of the trial beyond that date would prejudice him. That is his speedy trial demand right there. Rick, by counsel, also noticed a motion seeking the special judge's recusal. The trial court ordered the clerk. This was like the most stunning thing, like out of a series of incredibly stunning things. The trial court ordered the clerk to remove Rick's filings from the record because Rozzi was no longer a counsel of record. The court also appointed 2 public defenders to represent Rick from her own county, 100 miles away from Carroll County, despite the fact that Carroll County has lawyers within it that are qualified to represent him. Attorney Baldwin filed a motion requesting the court reconsider her order to remove he and Rozzi as Rick's counsel of record. In the motion, Attorney Baldwin argued that his oral motion of withdrawal was involuntary. The court rules outlining the proper procedure to withdraw as counsel were not complied with, that he and Rozzi were not disqualified and remained as counsel of record at the time that they filed the motion on Rick's behalf for the judge's recusal. The court lost jurisdiction to take any further action in the case until the motion to recuse was resolved. I think that's true. What do you think?
I decided to hop onto the Indiana Supreme Court docket and see if they entered anything on this.
Oh, so is that your way of saying you were completely ignoring what I was reading?
Yeah. So
fair.
The removal interfered with their attorney-client relationship, or that?
No, it basically they were saying that she was like the court lost its jurisdiction to take any further action in the case until the motion to recuse was resolved.
Yeah. Absolutely. We said that on our live when it was filed, that in the typical procedure, when the defendant asked for the judge to be removed, it goes to a different judge and nothing is done by that other judge until afterwards. That would be, I don't know that she loses jurisdiction in the truest sense of the word, because it means a lot more than that. And, but
ironically, who would have heard that? Who would have heard that motion? Like, she can't rule on whether or not she should be recused, right? Like, so they would have had to go to
correct. And then you said that somebody had said in the chat, or you, that the chief judge is the judge that already recused himself. So some other judge in the county where it actually is.
Well, you know who's deciding now? The Supreme Court of Indiana. That's who's deciding now. Okay, so, and removal of counsel interfered with their attorney-client relationship and prejudiced Rick's constitutional right to counsel. The day before the hearing, scheduled on October 31st, her second Halloween hearing in a row, attorneys Baldwin and Rozzi entered their appearance as Allen's retained counsel. In their appearances, Baldwin and Rozzi reasserted their belief that they were improperly removed as counsel of record and that they were now entering their appearance as private counsel in order to protect Allen's constitutional rights to a fair trial and a speedy trial, and to honor his 4th, 5th, and 6th Amendment rights. On October 31st, a hearing was held. Attorney Baldwin stated that Rick had asked them to represent him, so they re-entered their appearance. And the court asked, what had changed? Mr. Rozzi? So she sat the first, like, this is the stuff I was feeding Kara. Like, cause like Rose, like those guys were in and out of the courtroom. Like, I was sitting here watching it, and then, and then Brad's in the middle of it, and you know how you're in the middle of it. You're not committing everything to memory. Like, she put him on so after he gives kind of his initial salvo, like when she sat there for 2 minutes, didn't say anything after Labredo had filed his motion to continue the trial. She just sat there at her bench. She's like, well, Mr. Rozzi, like he stands up and he's like, oh, well, she's like, well, and so he goes through that. And then she says, okay, well, what has changed in the 12 days since you voluntarily withdrew? And Rozzi argued that their withdrawal as counsel was involuntary, so as to avoid prejudicing Allen's defense by allowing the court to disqualify them. He called it in court. He called it a strategic move. That's why he didn't do it. That's why he said, you know what, I'm going to file it as a written motion, but strategically, because he was protecting his client. He was shielding his client from all the things that we discussed previously earlier. Okay, so as to avoid prejudicing Allen's defense by allowing the court to disqualify them. He also argued that Rick had a constitutional right to counsel of his choice. He had asserted that right, and the court had no authority to remove his counsel without due process. The state indicated it agreed with the court. Can you believe that, Al? The state agreed with the court.
Shocking.
It's shocking that Rick's counsel were grossly negligent. I remember he stood up, old Nick McClellan.
Yeah, I think the court's right. They're grossly negligent, and they lied. They lied.
Like, he didn't say what they lied about. He just said that they lied in their memo. The state reiterated the examples of negligence the court had noted during the in-chambers hearing. So the court acknowledged that Rick had chosen attorneys Baldwin and Rozzi as counsel, but refused to recognize them as his counsel, stating that I have grave concerns, Mr. Allen, about the representation of you. The previous findings by this court of their gross negligence. Which findings, Your Honor? Please. Hello? Your Honor, please. What findings? Mr. Allen, you were entitled to adequate representation in your case. You were entitled to a vigorous defense in your case. No shit. Really? And this is difficult, Mr. Allen, because I know what you want. You've indicated that through your attorneys, but I cannot and will not allow these attorneys to represent you with the concerns that I've had with the gross negligence that I've found. What? They withdrew rather than be found grossly negligent and be removed. I can't do it, sir. I just can't. I cannot allow that. End quote. It was unbelievable, man. Like, slack-jawed. I was sitting there in the front, like there was one row of empty seats, and then I was essentially just sitting there as she said all this. You know how hard it was for me to keep my big mouth shut? I felt like being like a kangaroo court, like bullshit. It was crazy. It took and I'm sitting there with Hennessy, it's like Clee, it's me, Clee, and then Hennessy, David Hennessy. Like, him and I he told me a great joke that I would never say on live, but I'll tell you, remind me to tell you. And it was Halloween. So it was a Halloween joke. So, and he's like, look, he's like, I gotta get up there to talk to him. I'm like, well, what are you waiting for? So he stands up, tries to enter the well of the courtroom, and some big SWAT dude standing there. Big guy that's looking at all of us, making sure we don't have our phones out the entire hearing, and he doesn't let David in. He's like, I'm an attorney. I'm Andy Baldwin's attorney. He's like, I don't care. So he then walks behind the bar of the court. He's like, Andy. And he's like, tell the judge that I want to get up there and speak. So at that point, Hennessy got up there and he made a record. He's like, I want to make a record of everything that's going on, because your honor doesn't make records on this case. I'm going to make a record for the appellate court so they know what happened here today and what happened preceding today. So thereafter, the new attorneys requested a continuance of the January 24 trial date. The court granted the request and set an October 24 trial date, noting that counsel had not received the discovery and were unable to estimate when they would be ready for trial. The new attorneys admitted that they could not tell the court with any certainty when that they would be ready in October of 2024. So the court also noted that it had not completed a review of the exhibits related. So the court also noted that it had not completed the review of the exhibits related to the Franks motion, and that once new counsel had time to review the discovery and the pleadings, that they could either adopt those pleadings or make your own. Okay, so that's basically the story. She lays it out. Kara did an amazing job laying it out. That's how it went. And she got most of it in. And just so you guys understand, there are page limits. I don't know where my beautiful wife went, but like no one battles the page limit demon more than Allison when she's drafting any kind of motion or any kind of petition, because they have very strict page limits. Like you go over the limit by 10 words, they're striking the whole pleading. Like it's serious. So she was spending all night last night trying to pick and choose what to pluck out. So like if you're like knowledgeable about the case, like Sleuthie and I know pretty much everything about it and every pleading and every word that was said. And I'm like, oh, well, why did she say it? It's because like if it's not in there, it's because it had to go. You know, it's like the page limit thing is for real. So these are the grounds for the writ of mandamus. Now, this is the law. So she's laid out the facts. She's laid out what's happened because, you know, the Supreme Court doesn't know until they know. So she tells the story for them right there. And that's the defense's theory of what happened. That's their side of the story. Now, of course, the state's going to have an opportunity to respond. And we're going to talk about that afterwards. And like Allison already said, they're going to couch it in very different terms. They're going to couch it in the terms that exactly what our prosecutor friends are saying, that she was giving them an act of kindness, allowing them to withdraw without pantsing them in public. The only problem with that argument is that there was no due process and no hearing. You know what I'm saying? Like she couldn't say it even without the hearing. There wasn't due process. There was no notice. They couldn't even have prepared for that hearing. Like she was like, that's where the problem's going to be for her. It's not that like, oh, well, I'm giving you this gift of allowing you to withdraw without me pantsing you. The problem for their argument, and I'll predict it now, is going to be the fact that she did not give them proper notice that hearing was taking place on that day in order for them to get their witnesses there. And Hennessy went through a laundry list. He was great. Guy's like a legend. Goes in there and, you know, he just spits it to the judge. Like all the witnesses they would have called about how she's wrong about everything. All right. So the trial court lacked any authority to remove Rick's entire defense team over his objection and based on the summary finding of gross negligence. The key word being summary there. Original actions provide extraordinary remedies, and accordingly, writs of mandamus and prohibition will be issued only where the trial court has an absolute duty to act or refrain from acting. And they cite the cases. I'm not going to read the case citations. This is out, that document's out there for you in the world. If you're so inclined to go and you want to start reading some cases, maybe you do. You know, I mean, if you do, you might as well just go to law school because that's what it's all about. This court routinely relies on its original jurisdiction to address claims that attorneys have inappropriately been disqualified or that they should have been disqualified. Allison, what does it mean? What does the term this court, meaning the Supreme Court, routinely relies on its original jurisdiction to address claims? What does that mean in lay people's terms?
It means that we have brought the precise thing that you use to do what we are asking you to do. That they use writs of mandamus to do this precise kind of thing and have done that in other cases in this state and in other states through their highest court. Right.
Okay, here the trial court has an absolute duty to reinstate Rozzi and Baldwin, and the remedy on appeal is non-existent. What do they mean by that? Meaning, say, for instance, they go through the trial. Richard Allen's convicted.
Right,
he appeals it. It's too late. You can't,
right.
like, you can unring the bell. The trial's already happened.
Right.
So they need to point that out.
And that's why, and I've said it on a couple of the lives, they call that a structural error. Meaning like it's not one that they have to show, you know, whether it was harmless or prejudicial. It's like one of those things that you just can't fix. You can't put a finger or determination on how it was or wasn't prejudicial because he was completely denied, you know, the lawyer of his choice.
Yep. Okay. Here the trial court has absolute duty, blah, blah, blah. Sixth Amendment to the Sixth Amendment to the U.S. Constitution provides in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. The right to counsel embraces not only the assistance of counsel, but also the reasonable opportunity to secure counsel of one's own choice. And they give the case citation. The attorney-client relationship, once established, is inviolate and should not be severed or subject to unwarranted interference. That Latta v. State looks like a pretty good case. The attorney-client relationship is afforded the same venerable protections, whether the lawyer is a public defender, acting pro bono, or privately retained, which is an important distinction. Like you and I were talking about this. Like you were teaching the people, when we were talking about the continuity argument, and you got all mad at me, and you said, "Oh, the districts are split." Remember?
Yes, I asked you if I would speak out of turn on that.
Right. So Indiana recognizes only two narrowly circumscribed situations where a trial court may sever the attorney-client relationship against the client.
All right, now let's see. Is one of them gross negligence?
Grossly negligent, sirs. I find you.
All right, Indiana. So the first one is a lawyer is not a member of the state bar. That one makes sense. You're not licensed to practice here, chump. You got to go. And two,
Wow.
or the lawyer has an actual conflict of interest that will obstruct his ability to provide effective representation. That's it. And there's the case site for you. So
I don't know. Neither of them sound like gross negligence.
I mean, there's not even words that I could pretend look like gross negligence.
No, nothing that deals with your
I have a feeling so. The Supreme Court of the United States once defined, like when somebody asked them to define pornography, I forget which justice it was, but he said, "Well,
no, let me see it.
Always stealing. That's it. I can't define it, but I know it when I see it." Like I think that Fran Gull is like when they say there was oral argument. Well, Judge Gull, what do you consider gross negligence? Well, Your Honors, I can't define it, but I know it when I see it. And that was it. That's going to be your argument.
Well, so but gross negligence does have an actual definition in the law, and it's just something more than mere negligence.
But not really in the context of criminal law that much. I mean, I see
not
it.
Not at all.
I see it in civil law. Well, where does a criminal case? I don't know. You know what I mean? I don't know. No Indiana court has ever tolerated a trial judge removing a lawyer from a case over the client's objection. I want to read that again. No Indiana court has ever tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief that the lawyer is negligent or even grossly negligent, period. In courts across the country regularly issue extraordinary writs in criminal cases to reinstate defense attorneys who have been kicked off cases for conduct the trial court found upsetting or negligent. And then they list a whole bunch of cases where that's happened. When a court believes it possesses objective evidence, see that's the argument with Gull. She has lost all objectivity. She's completely subjective with all this. And that's why Kara or Mark, one of the two of them, italicized that. See that little tricky italicization? So, okay, italicization. When a court believes it possesses objective evidence to support a lawyer's removal, it should clearly articulate that evidence on the record and, quote, exhaust other possible remedies before resorting to the removal of counsel, end quote, such as censure. What's censure, Allie?
To basically a gag order.
Right. Or she could yell at him on the record.
Oh, yeah. They could yell at give him a little wrist slapping.
Yeah, but like they'll yell, like I got yelled at in court a couple times, like on Dude's case. Like the judge is like, "Oh, I told you not to do that anymore. Quit arguing with the witness." I'm like, it's cross-examination. Okay. where was I? Okay, disciplinary referral or contempt proceedings. None of those took place here. Removal, if ever considered by a judge, should be an absolute last resort. And the removal proceedings should occur at a hearing where the defendant and his chosen counsel are provided notice and an opportunity to be heard on why the attorney-client relationship should be severed. Okay, here the judge acted to terminate the attorney-client relationship when she had an absolute duty to refrain from doing so. This court should mandate attorneys Rozzi and Baldwin be immediately restated. Attorneys Baldwin and Rozzi were active members of and in good standing with the Indiana Bar, and there is no conflict of interest, even alleged, between Rick and his attorneys. The inquiry should end here. But attorneys Baldwin and Rozzi were removed because the trial court disagreed with their conduct. It's that simple. Like the whole thing that I don't know, I can't remember because I was listening to this as we drove home, where Rozzi said, I think you're pissed because of the memo. And she got so upset. She's like, I didn't say anything about the memo. Where did I say something about the memo? I didn't mention the memo. Like that whole exchange was unbelievable. Because he called her,
who protest too much.
Doth who protest too much. That's right, babe. But attorneys Baldwin and Rozzi were removed because the trial court disagreed with their conduct. The judge made a sua sponte summary finding in chambers of gross negligence after the state raised the issue of disqualifying them. It is entirely unclear from the record what the court found was gross negligence. The record only includes Attorney Rozzi's recollection of the acts mentioned by the court because Rick has been unable to obtain a transcript of the in-chamber proceedings. Like, yeah, I mean, I didn't finish the story, but I tweeted it. I mean, when Sleuthie and I requested, the judge emailed us back. I told you that, right?
You told me. I don't know.
Yeah.
About the
So
rest of the
like when
world.
Sleuthie and I said that, I hit Sleuthie up. I'm like, yo, email the judge, say that you and me are requesting, we want to have a hearing of the actual audio. And, and Sleuthie said, Attorney Robert M. Mata, blah, 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 blah. And she sends back the email. I should actually try to pull it up. I will at the end. It's good. But she says it's private and confidential. How can it be private and confidential if you've recorded it? It's of record. If it's been recorded by a court reporter, it is of record. How can it be private and confidential?
No, that's not necessarily true.
Hmm.
She has to do that thing that they said.
Rule 6.
Right. But there is a process by which, even though there is a transcript, that it is nonetheless confidential.
Right. So that was the next email. Like, okay, well, where's your Rule 6 explanation as to why it's private and confidential? Except I don't even think we sent it. Nevertheless, the judge's subjective allegations of gross negligence fall into two categories. One, a mere disagreement with the zealous defense tactics, or two, concerns about the unintended release of evidence, which objectively had no effect on the lawyer's ongoing effective representation of Rick. A Sixth Amendment interference with counsel claim is at its zenith when a trial court dismisses a lawyer because it disagrees with competent advocacy.
Have they not cited Gonzalez yet? I have not seen Gonzalez.
I don't know. Why don't you cite it? Why don't you tell people what Gonzalez says?
Let's just keep reading and see if they do it. I'll talk about it again.
All right. That is precisely what occurred here. Once attorneys Rozzi and Baldwin were appointed and became Rick's counsel, the court lacked any authority to obstruct and sever that relationship. If the court found their conduct upsetting or negligent, it should have been clearly articulated that evidence on the record and exhausted all other possible remedies before removing them from the case, such as censure, disciplinary referral, or contempt proceedings. She had an absolute duty to refrain from obstructing and severing the relationship, especially where Baldwin and Rozzi suggested a remedy in the event the court was considering removal, which was, again, docking them pay, like a week's pay. I think it was like 40 hours of pay, docking them. The court should grant emergency relief and reinstate Rozzi and Baldwin. But reinstatement of Rick's counsel of choice is not sufficient to remedy the violation here. Rick was pursuing a speedy trial and third-party guilt strategy. He intended to file a speedy trial request in early November. but the judge kicked them out of the case, rejected their appearance, and struck their pleadings. The court is the only court in the state that can order a speedy trial date. This court, the Supreme Court, can still say, Rick Allen's speedy trial date, we're sticking it back at January 8th, and we're putting Baldwin and Rozzi back on the case. Good luck, McClellan. If it does not seize this opportunity now, it will forever be lost. There is no post-judgment remedy available. What's that mean? Tell the people.
They don't. Well, it's essentially what we've been talking about before, that there's just no remedy after the fact. You can't technically you could redo the trial, but there's all that harm of having to redo the trial.
Right. Okay. And they also go on to say that a new judge should also be appointed to avoid the appearance of bias that will otherwise permeate these proceedings. Quote, a judge shall disqualify herself in any proceeding in which the judge's impartiality might reasonably be questioned, including circumstances where the judge has a personal bias or prejudice concerning a party or party's lawyers, or personal knowledge of facts that are in dispute in the proceeding. Clearly that's happened here. She said it as much. She can't say that she finds them to be grossly negligent in the representation of Richard Allen and then unring that bell. It's out there. It's like that's it. It's been said. She can't, if they are to continue, they can't keep her on. She has outed her bias of them. They can anticipate that she'll rule against them on every motion just because of her bias. Or it's certainly going to feel that way, even if she's not doing it. You know what I mean? Like we would be thinking it. It's like the case with our judge, where I asked him on the record, I'm like, are you going to hold against us the fact that you were so pissed off about the last case that we won, that you're going to take it out on this client? It was scary to do that for me, but I did it because I did it for my client. I wanted to know, because we were thinking about going with a bench trial where he's the old trier of fact. I had to know. I had to ask him. And surprisingly, he just answered. I thought for sure I was going to be held in contempt. Okay, I forget where I was. Bleep, bleep. Okay, the commentary to this canon. The judge would. Okay, yeah. The commentary to this canon provides that under this rule, a judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless of whether any of the specific provisions of paragraph A1 through 6 apply. Here, the judge
we talked about before, calling it the appearance of impropriety.
Right. Here, the judge summarily found that counsel were grossly negligent and publicly proclaimed that she has grave concerns about the representation. So she's articulating what I was just saying. The judge also emphatically stated that she could not allow them to remain as Rick's counsel, given her concerns about the representation. It's clearly bias and clearly subjective. There's no objectivity whatsoever in that. For many Hoosiers, I love when she puts that in there. For many Hoosiers, this case marks the first time they have followed the workings of an Indiana court. Yet, for all rulings going forward, the public will question the judge's impartiality. It's exactly what I just said. Even if she's actually being impartial, people are always going to wonder, did she deny that motion because she hates them? It's like you can't escape that. To restore the public's trust in the integrity of the judicial process in this high-profile case, a new special judge should be appointed. Conclusion. See, it wasn't that bad, Bay.
No.
To ensure that going forward, Richard Allen receives his fundamental right to counsel, a writ of mandamus is appropriate to reinstate attorneys Baldwin and Rozzi as court-appointed counsel, to set a trial date within 70 days from the issuance of the writ, and to remove the special judge and appoint a new one. So that's kind of what they call a wherefore clause typically. Like that's what you're asking the court to do. And Allison and I were having a discussion, and she actually had wanted me to call Kara and bring up the fact that, basically they're saying that she wants them to reinstate Baldwin and Rozzi as court appointed counsel. And Allison was like, well, should we put like an alternate, or in the alternative, recognize their appearance forms as private counsel? Because, like the Supreme Court, if you didn't ask for it, if you didn't ask for the remedy specifically, they're not just going to give it to you. So Allison was concerned if, they're going to say, okay, well, we're not going to reinstate you as the public defenders, that now they're just shit out of luck because they didn't add in the alternative of, okay, well, if you're not going to have the county pay them, then let them come in pro bono, let them file their pro bono appearances. And I called Karen and I talked to her about it, and she's like, we discussed it, and we're leaning completely into, and I'll ask her about it on Wednesday to restate it, but we're leaning completely into this concept of, they don't care if they were court appointed or pro bono private counsel, that the analysis doesn't even get to the point where they had to enter their appearance pro bono. They think that the analysis ends with the fact that she had no right to remove them in the way that she did when they were appointed. So that was her rationale for not, and they clearly, her and Mark talked about it at length, because like Allie was concerned. So I called her, and we talked it out. So that's it.
I'd like to go right into the questions that like the members or the super questions people have. And unfortunately,
question time.
I accepted your little invite thing, but apparently I didn't log in. So I still can't do that. But if someone can highlight, let's say Janie Lane, it was like 914. She asked, how was she appointed?
No, it's got to go up. Like, let the mods put it up. I'll go through. I'm going to go so as you guys know, if you listen to our podcast, we turn these into episodes of the docket. So the way that we're going to be doing this forevermore is we're always going to be giving shout outs in the middle and questions in the middle, because it's too hard for Darren to pull out the questions, and it destroys the continuity of the episode. So like, we're going to do that this way. Like, so just so y'all know, we'll always answer your questions, and we'll always shout you out if you're super generous and you're throwing money at us. So which one was it, Al? Why can't you just start at the top? Like, let's just start at the top.
Well, because some of them are just, which I know you'll do at some point, like recognize, and they can put those up, like people who have just made a comment, but I'm looking for like, and I wanted
actual
to answer
questions. All right. So which one do you want to start with? Give me the name.
All right. So how about Pat May? So what's going to happen now is everything on hold until the Indiana Supreme Court decides all these complaints. So that first off, let me just say this. So the as far as the first writ that was filed, so October 30th, so the Judge Gull did have lawyers enter their appearances. You've got a Matthew Gutwin, Gutwein, and a Christopher Stake. And initially they were supposed to have their response on filed, I believe it was on the 9th. Yes, on November 9th. But Judge Gull filed a motion, an unopposed motion for an extension of time. So the Supreme Court has given Gull's lawyer until November 16th to file a response. Unopposed motion for an extension of time. Any briefs opposing the issuance of the writ must be filed directly. Okay. So that's on the first case. On the second case that was filed today, that is also, responses are due November 16th. But in the same sense as it went from the 9th to the 16th, it's possible this could go from the 16th to another week, another 10 days, or a week down the road. And then I suspect, but this is the type of thing that the Supreme Court doesn't have like a hard and fast rule, at least usually not, of when they must respond. But this is the type of thing that they do very quickly when there's a pending criminal case. So I think everything will, and actually, I guess I don't know the answer if everything will proceed or if it's sort of in hold in the lower court while this is being done, because this writ of mandamus is not your typical, it's not the same as like an interlocutory appeal. So then we've got precedents.
Babe, before you go to the next one, that was one of the things they're asking for. They're asking for them to stay the trial court and everything they're going to do. So that's one of the things they asked for in this writ.
Okay, so it doesn't automatically do that based on the fact that they asked for it. Right. Where an interlocutory appeal would or might, depending on the issue. If Richard Allen gets released, what's a CERN 70-day deadline? Does she mean like the speedy trial?
I'm assuming that she means the Speedy Trial Act, 70-day deadline.
Oh, okay. All right. So, I mean, technically, yeah, or they could dismiss without prejudice. And I think they can dismiss without prejudice and they have a year to refile. It depends on the state. But I think that they might have a second bite at the apple.
If they dismissed it and they had 1 year to rebring it, he would get out. They wouldn't be able to hold him in custody.
Yeah, but then any time that they cause this delay, it would get counted. So they wouldn't get the full time back. So, there's a little more research I've got to do in Indiana's speedy trial statute to determine if that would be it and they'd have no second bite.
So here you go. Tiff Knox question. How often have you seen someone walk from a speedy trial request that was not met?
Very rarely.
Very rarely. Very rarely. I mean, the state, like, everyone knows the date. It's like, as it approaches, everyone's aware of it. And it's that thing where the state knows it's there. The defense knows it's there. The judge knows it's there. And it's like it's used as a tool, like a lot of times. It's used as a tool. Like Allison will use it as a tool to try to get something accomplished by like have the speedy looming over them, like in terms of she's trying to get them to come up with like a plea agreement that she thinks is reasonable. There's a lot of reasons. There's a lot of strategy behind it.
That's usually the number one way not to get a decent plea agreement.
Right. It pisses them off.
Right. But I do want to point out that even though you make your speedy trial demand, by them asking in this writ, and, it's so weird how they speak for Richard Allen, but they're not
Richard Allen's
lawyer.
Well, the relator is, she entered a limited appearance for him. She's not trial counsel, but she has a limited appearance entered in the trial court.
But is it like literally he asked her to do this, that type of thing? Or it's like you can do that on a writ on behalf of somebody, even though they haven't, I don't know. But let's say Richard Allen has literally asked for this relief and that's how it's considered. That's going to toll his speedy trial demand because they are asking the lower court now not to do anything until a certain decision is made. So that would end up tolling it. So let's say I make a speedy trial demand, but then I go in and I ask to continue trial. That time that I'm asking, doesn't count in the clock for the speedy trial. It would be, it would not be counted. So any delay that the defense acquiesces to, like says, okay, I agree with that, or requests won't count in the time.
Okay. And all right. This is another one. Samantha C. $5 holla. Thank you very much. Outside attorneys getting involved in a case like these filings by Kara, is this pretty rare? Have you seen this before in other cases?
I'd say it's very rare.
Very rare.
Yeah. Usually it's all your trial counsel. And that's what I'm saying with these writs, it seems to me, and I did a little bit of research, but not much because, I've got real clients, but that there are times where like someone can file like on the defendant's behalf, even though the defendant hasn't asked for it to happen. And I don't know if that is what happened here. It seems like that might have been what happened here, but I don't know, because they are asking for relief right now, very specific to Richard Allen, where before they were asking to relief, like make the judge put things on the docket. You don't, that's not real specific to Richard Allen. This is directly specific to Richard Allen. And, you know, it's since this is an area of the law, like a writ of mandamus, that is very particular and outside the normal sort of course of your average criminal lawyer's practice. For that reason, for this type of motion, I'm not surprised they have outside lawyers helping them or doing it or whatever the case may be. But either way, all of this is very unusual.
Super, super rare. Okay. Janie Lane, how was she appointed? Did she volunteer or was she chosen randomly? Who chose her?
Do you know the judge?
The Indiana Supreme Court chose her. Like that's who appointed her to it.
But like randomly on a.
I don't know if it was a wheel or if that, I do not know. And I don't want to guess the answer. I don't know how they landed on Gull. I know that Gull has made 3 runs at getting on the bench at the Supreme Court of Indiana. I don't know if she's been helping her cause with the way she's handled this one.
Just don't know. Not sure about that one.
My King of Kings, Bob. Is this a way of getting the defense back on the case because they know the case and the new guys won't have enough time? I mean, it's definitely that. I mean, it's like 100% that. Like, that's a great argument in terms of trying to get the you want to make the argument. It's like the victims' families are the ones that are paying the price for this delay. And this delay was unnecessary because the judge was way out of her purview. She didn't have the right to do what she did to begin with. Like, so here's a theory. So the way that this thing goes down is that there's an early hearing. Now y'all are gonna have to come back on Wednesday. I'm gonna let Kara tell the story about when the judge first heard about them, because the judge, under no circumstances, and I was saying it all the time, I was dead wrong about it. Like, I was like, there's no way this thing's going to trial in January. No way. So when I heard that these 2 guys were like, we're ready, we're going, you know, it took me by surprise. So imagine if you're the judge sitting on the trial. Like, so she was like, make sure you're here Wednesday. Kara's going to be here. Sleuthy's going to be here. Allie's going to be here. It's going to be 3 awesome women and me trying not to talk the whole time. Okay.
Wednesday,
so, yeah,
what time are we doing that, by the way?
Wednesday.
What time?
I think we're going to do it 7 Eastern. So that's 6 for us. Okay.
I was just going to say, I have a busy court day on the 8th.
Oh, I'm sorry.
No, I'll be back at night.
All right. Okay. Let's see. Okay.
And yeah, just also to follow up with King of Kings, that's part of the argument that they incorporate here is that this is impacting his right to a speedy trial because, like you said, these lawyers know the case. These lawyers could be done and ready in time, and the new lawyers cannot.
Right. And all right. So question from Pat May. Why didn't someone, Allen, Rozzi, or Baldwin, call her out while the camera was rolling? Honest question.
So I think that they address that in here. I don't know if it's the real reason, but what they write in the memo is that by having it proceed to a hearing, it would have implicated his right to a fair trial because it would have disparaged his lawyers publicly, thereby disparaging his case publicly, so that they avoided that at all costs and also didn't want to create an actual possible, conflict of interest by them being, as Bob likes to call it, pantsed in public. But I'm sure, Bob, you've got some more opinions and info on that.
I mean, look, the bottom line with it is that they didn't get the opportunity to go into the well of the courtroom. If you're talking about why didn't they go to hearing, that's a different thing than them calling her out on camera, because by the time she came out on the bench, in her mind, Baldwin had already withdrawn and Rozzi had promised that he was going to withdraw. So
But she was not giving them the opportunity to speak.
Exactly.
Unless they would have chose option B or option A, whichever one that option was.
If they would have taken the nuclear option. JD, $10 holla. Such a nutso situation. I admire Rozzi and Baldwin's tenacity and resolve. As do I.
So do we.
All right.
Well, you're welcome, Jennifer.
Thank you. Oh,
Thank you.
member for a month.
Member.
Thank you, Jennifer. We're glad you joined the fam. Love to have you here. Jules of All Trades, True Crime. Jules of All Trades, True Crime became a YouTube member. Hoot, hoot. And we love when you all become members. We love our members so much. And we're going to start doing cool things for the members. Like, I'm getting way more acclimated with YouTube. So it's like a learning curve, but I'm getting better. And when I get better, and I've got amazing mods who we want to thank all of them for being here and crushing the game. Like, there's so many of you guys. I don't even know how many are here because I'm not in the live chat. Like, and I don't want to name them and forget them. Like somebody be like, oh my God, he didn't even say my name. Like, but I know Mandy's here. I know Carly's here. I know Stevie's here. I know Dizzy's here. Like, I don't know if Jay's here. Jay might be here. He might not be here. Sandy, stop it. A brand new Sandy Allen is a new mod for us. Thank you so much. She's here. I'm going through Janet, another mod. Thank you so much. See, I'm not on, if I was watching on YouTube, I could see the wrenches. So I know, so I'm having to go by memory here. Who else we got here? I just added Law Nerd Amber. Thank you very much for modding. Shan's, I don't know if she's here. I don't know if Dan's here. I don't know if Steve's here. Those guys are all mods. Stevie, if you guys, whoever's here, I love you guys. And just know that I'll figure it out. And I have great love for all of you. All right. So let's see what else we got here.
Well, Desiree D and Lisa love your reading.
Oh, thank you. Allison's indifferent. Like, she could live with it. Charmaine gifted 5 Defense Diary podcasts. I think I'm going on a live with Charmaine. Is that true, Charmaine? I think y'all want me to jump on with
Angie.
you. Definitely do that. 5 Defense Diary memberships. That's amazing. Thank you. Angie, Allie's hair is fire tonight. Sure is. Sure is. Do we get MJ? Right. Time flies when you're having fun.
Yeah, it was up there.
Oh, good. Greg Nugent, $4 holler, super sticker. You're the man. Appreciate you, brother. Anon, $2 holla. Appreciate you. Kate Saldana, $5 holla. Appreciate you.
Thank you.
Dara. Like, I hope it's Dara.
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 I say Dara, but it could be an East Coast Midwest thing, like you're always saying. Lauren,
it could be. Whichever one it is. We love you either way. Thank you for that membership for 1 month. That's awesome.
I saw that.
$5 holla for precoisant. You're amazing. Thank you.
What?
You're always.
Why did you say it like that?
What?
Her name or her username?
What do you mean? How would you say that?
Well, you said, well, I'm assuming it's precoisant. Yeah, you butchered it, but I know I've heard you say it right before.
It throws me off, that name, every time I see it, but it's that eyeball staring at me. So yeah, stop it, Bob. Allison is hot enough to do whatever she wants. True story. Hit the thumbs up, peeps. Another $5 holla, $10 holla total. Question: if RA gets released, Jen, thank you for becoming a YouTube member. All right, let me see. If RA gets released,
we answered that one.
Never mind.
Okay. All right, Desiree, we don't hate it. I stopped everything to hear this. Much respect to Bob and Allie. Thank you, Desiree. Thank you for that $5 holla. Lisa Lang. I want Bob to read all the documents, and I want Allie to continue to tell him to move along. Yes, that will never stop. That will never stop.
Actually put it
thank
in
you
the private
very much.
chat that you never look at. I was like, keep reading.
Yeah, it's like if we were in court, that
Charlie
would be
saw
her
it.
kicking me under the table, kicking my leg, which always irritated me. Like, why are you kicking my leg? I'm in the middle of a cross-examination. Lisa Lang, thank you also for becoming a new member. Jennifer Johnson coming back for more, gifting one Defense Diaries podcast membership. Thank you so much. Marielle L, new member. Welcome to the fam. We love having you. Oh my God. So like, do you remember how I want to say Cassia? Like I should know because I
Yeah,
met her, hung out with her.
She
so
actually
long.
put it in like
Right.
last.
Cassie. Type it again so I quit butchering your name. And she's a mod, for God's sakes, who I forgot. So like, yeah, make sure I'm pronouncing your name right. Carly, when the correct pronunciation comes up, I mean, in my defense, it's not how it reads phonetically. So, but thank you so much for gifting 5 Defense Memories podcast memberships and being a mod, not only here, but on Facebook, or maybe you're just Facebook. I don't know.
So with regard to, am I boring you's question, I think that the affidavit last time was sealed, and your guess is as good as ours on why not public. I mean, that's part of the whole reason the first writ of mandamus was filed.
Right.
Tasha.
Thank you.
So much easier than I thought.
I know. I think last time she typed like CAW.
Right, which made me think it was Kasha.
Kasha, right. So Kasha, thank you. All right, I will not screw it up, Kasha.
Dr. G, thank you.
Yeah, $10 holla. Cup of Joe for Allie for burning the candle at both ends with all of this while having an active caseload. For real. That is gospel there. And Mimi, 62, new member. Thank you so much for joining. That's amazing. So, all right. Anything else you want to talk about?
Well,
we broke the 2-hour mark here. I think it's pretty ample.
Yeah, I mean, just that I think that the court will act quickly, but I think that the person who's going to know the actual answer to an approximate timeline and how long the court usually takes and what this all usually looks like is going to be on Wednesday.
That's right. Wednesday night. Kara is joining us. So Kara, Sleuthy, Allie, me, we're all going to be here and we're going to get into other stuff. That's going to be a great night for you guys to jump on, to ask Kara all kinds of questions. And like, well, let me ask you, let's kind of end it on this. What's your prediction? What do you think? What do you think the ruling is going to be? Without the benefit of having, like, obviously we have not seen the judge's response. She will respond. So, we can anticipate that she's going to have her side of the story. So, but without having the benefit of seeing that yet, I mean, how do you feel about the strength of what they proposed?
I mean, I feel like at the very least, worst case scenario, I feel like the court must mandate that there's a hearing. Like if they do nothing else, I feel like they have to mandate that that it go back and there be a hearing.
But like, I mean, she's already given her answer. You know what I'm saying?
I know, like, but they're going to want a hearing and they're going to want the specific reasons on the record.
And then they'll decide if
if they file another appeal or an interlocutory appeal. I don't know, because this whole writ, and that's what we're going to have to ask. Is it Kara? I'm so sorry.
Kara, yeah.
Yeah, Kara. Like how it works, because in a typical interlocutory appeal, they'd send it back. They'd say, do it again, do it right. And then if somebody wanted to appeal again after it was done right, then there would be a record by which they could rule on it. But these writs of mandamus work differently. The dog is yelling. He's like, it's been 2 hours. Can you hear him?
I can. He's talking. That's how he speaks.
Yes.
Shannon Timmons with the $5 howl. Thank you so much. Thank you.
I'm gonna let him out.
All right. Okay. So Carly, were there any non-members slash just regular folk that had a question that you thought that I should answer, or any of the mods? Did you guys see anything? Because I did not have the opportunity to go through. I was reading, so obviously I couldn't read any of the chat. If there's any up there, if we got a few of those, I'll be happy to answer them, especially while Allison's gone, because she's a real stickler for y'all being members. Okay, but what will be the outcome of the hearing from Janie Lane? I'm sorry. But what will be the outcome of the hearing, and what happens to RA this whole time? Do Baldwin and Rozzi remain as attorneys in interim? So at this point, they're not as attorneys at all. Okay. And like it'll depend. I mean, in theory, the thing that the Supreme Court should rule on first is whether or not they're going to agree to stay what's happening at the trial court. Like, because technically Gull could say, okay, she could call Scremin and Libredo and said, okay, get ready. I'm having this hearing before the 16th. I'm having it like she could try to run.
But which hearing would she be having?
Like the Franks.
Oh, no, they're supposed to figure out whether they want to adopt it.
But that's what I'm saying. She could in theory, because I'm telling you, her and Libredo are buddies. She could say, okay, I'm scheduling this hearing for the 15th of November, buddy. So be ready for it. And try to squeeze it in. She could though. What's stopping her otherwise than a really bad look?
Right. Just making her, bad decisions worse, because that doesn't give him enough time to prepare for a hearing, or to just hasn't even decided whether he wants to adopt it or not.
All right. So we got a member question. Do you know if Rozzi and Baldwin were required to return all the state's evidence? What happens if they get restated? Well, they get it back. So at the end of that hearing, Andy said that he would return it. They'd return it at the end of last week. I don't know if they did or not.
But to answer your question is that they would be required, even if the judge makes a wrong decision. At this point, they're not his lawyer. They are not his lawyer, so they have to return it.
Right. Exactly. All right. Pat May, another member question. Bob, will you be going to any or all future hearings? Of course, 100%. I always go to the hearings. Grizzly True Crime, who I love. Grisella's amazing. She's so dope. Mentioned your update today. Many are watching. Thank you, Grizzlies. Welcome all you Grizzly members. You guys are amazing. Thank you for coming and hanging over here. I really appreciate it. Hopefully it was good advice. Hopefully y'all enjoyed it. Hopefully you gained something from it. That's what we hope to do, is educate a little bit, entertain a little bit, kick you with some knowledge, and give you just facts. So thank you, Pat May. I'm scrolling through here. I see so many great people in here. So many regulars of our community. Meredith, what's up, girl? See you hanging in here. See you. True Compass, what's up, girl? See you. Who else we got?
Thanks, Heavy Metal Rehab.
Thank you so much, Bob and Allie, for entertaining and the informative live. Thank you for hanging with us, especially for 2 hours. 210. We held on to damn near 1,300 for 2 hours. That's pretty good. It's pretty good.
And it's late.
And it's just you and me yapping, especially me, my big mouth. Why don't you let Allison talk more? Why are you always talking the whole time, Bob? Let's see. I am not T-Pain. T-Pain, what up, dude? Thanks for hanging. Art with Viv, love you. So this is all our community. Stevie, my man, always here. And again, y'all, I always have to give special shout outs to Stevie. Stevie comes up with those killer thumbnails for us, beginning graphics, does it on the drop of a hat. You know, it's like I'm about to hit him up tonight because he's got to get the graphic for. By the way, Stevie, if you're still here, I need a graphic, need a thumbnail for Kara and Sleuthy Wednesday. All right, let's see. So thank you, Stevie, for all you do. Desiree D, I'll probably be working Wednesday. No, thank you in advance. I'll try to sneak in on breaks. And replay crew. It's just there for you. I mean, you missed the chat, which is pretty awesome. You guys are awesome in the chats. I love to see it. It's so good. It's so good. Hopefully everybody's nice. I like when everybody's kind. Justice for all.
Conversation going on.
Love that name, Justice for All. Desiree
Oh,
D.
you never told them the movie.
Memo.
Memo.
Oh, God, it's Risky Business. He makes the memo minder. It's that little scene. That was a really tough one. Did anyone get it? Did anyone get Risky Business? Did anyone?
Anyone?
I'm afraid to answer Kate's question here. I feel like she's going to yell at me. So I'm going to take the fifth on that one, Kate.
Why she doesn't like?
Kate's yelled at me before. No, Kate's a hardcore prosecutor. Like she leans prosecutor side. So, like we've had it out. I respect her always, and I love the engagement. So I'm never afraid to engage in a spirited debate. I love them.
But he's pleading the fifth on the Christopher Vaughn thing.
Webweaver 68, thank you so much for gifting that fantastic membership. And I'm working on the music thing. I know all the good like channels have like little musics and little gimmicks and fun things that they do. We're not quite there yet. You get the holla though, the $10 holla. I don't know anybody's got anything better than that. $5 holla, $2 holla, $1 holla.
Holla, yeah, it's great.
Yeah, thanks, babe. All right, let's see.
At FOFA, which is
FOFA. Where's FOFA? I gotta add FOFA as a mod. Did somebody see FOFA in here?
Well, it sounds like FOFA guessed Risky Business. A few people guessed Risky Business.
Well, who's the first one to guess it? Like only the first one wins. People that copy the answer off other people don't win.
We don't know that's
John Lubers says Bob versus Allie. Allie wins. Sorry, Bob.
Yeah, sorry, Bob.
Sorry, I'll take it. You're probably right there, Jono. Okay, let's see what we got.
No, Christopher was a guy. Miss Maple asked. Christopher was a guy who is accused of killing his wife and children as they drove down on a family vacation
to a water park in St. Louis, like back in his trials in 2007. There's more to the story. That's all I'm going to tell you.
Yes, and as Kelp said, on your way out, please hit the like button. I know you can't kind of see it when you're in
subscribe.
Here. Once you close the chat, and subscribe, yes. Hit the like button.
Yes, please hit the likes. I don't know how many likes, but we had 1,300 in here. Oh, Catherine Hargrave with the $10 holla.
You got your euros.
Oh, I like it. Man, you know what? She's brutally honest, isn't she? Yeah. That's what I did there. Aspiring. We do not believe you get sick of talking. You know me so well, Aspiring.
Sure.
You outed me. Oh, here's my boy Ricky Cougar back. Oh, so y'all know I hung with my boy. Well, Dan wasn't there. Dan, did you have better stuff going on Friday night? Like, where were you for Friday, man? It's like
Friday.
Everyone should be subbed at Publicly Buzz and the Shaming of Jay and Joe Jackalone. They're all my homies in the game. But yeah, Dan broke my heart when he wasn't at Feral Friday at all. He was a no-show. Guess he had better stuff to do. That's fine. It's fine, Dan. I love you, but I'll remember that. I have a long memory. Dan. All right, let's see what else we got here.
I think we got everything.
It is 1L, A-L-I, Allie, just for clarity. Thank you for asking. She is a 1L'er. A 1L'er. Okay. It's a lot. There's so many. Like, this is me the other night. Like, I think you abandoned me. See, Miku's headphones. Also, I love the documents and y'all reading them and translating them into layperson legalese is so hard to parse on my own.
Oh,
Thank
good.
you,
I'm
Miku.
glad.
Thank you. Thank you. Thank you. Thank you. CH, impressive that Bob and Allie have those in Europe and the UK watching at 5 to 6 a.m. For real.
Crazy.
Excellent points. CH. Like people were like, yo, that's like the crack of dawn for me. So yes, all of our wonderful, wonderful viewers and subs out in the big wide world, thank you so much for staying up super late and hanging with us, because I know it is very late for y'all. Massively appreciated. And just remember, Allie and I are going to be at CrimeCon UK in September. We're super excited about it.
Real? It's a year from now.
That is it is a year from now, but it's in stone. Yes, Law Nerd Amber. Thank you to our global viewers. It's so appreciated. It's so amazing.
Yeah.
T-Pain. Let's see. Little baby Bobby Motto, Pawpaw's cousin. So we just found out.
Pawpaw, that was right. That's what he said. Pawpaw.
So we just found out we're going to be grandparents, and we're super excited about it.
I love Bob's voices. I try to get him to do them on demand, but he won't.
Sometimes I do. Not really, though.
You're going to tell everybody your grandfather name? I'm just not sure you're ready to do that.
I'm not going to tell anybody. I need to know what Allie really thinks about. Oh, yeah.
I just said I love them.
I mean,
how could
kind of hard to hate? Like, really? I mean, I would enjoy like hearing me do voices, I think. Maybe. I don't know.
Yeah, I enjoy them all, unless he's trying to do me in some sort of mockatory way.
Yeah, everyone hates when I try to mock their voices. Carrie RH, remember, 5 a.m. in the UK. Wow.
Thank you.
Tip of the hat. Thank you so much for hanging with us. Thank you. Thank you. Thank you. All right. I think Publicly Buzzed, Bobby coming on to watch a movie on Kick. For sure. So we're doing Star Chamber, which I love it. And y'all, Steve and Dan over at Publicly Buzzed have been.
Wait, so what does that mean? Guys watch a movie together and like your guys are laughing it up and
yucking it up, watching Star Chamber. Yeah, it's like Star Chamber, because like Steve was all over that. I made like a comment, a Star Chamber comment, and then he was Googling while we were on, and he's like, "Oh my God, Star Chamber looks awesome." And then Phil, he made an incredible little, like anytime Phil's on a live with us, like he goes like within 10 minutes, he's put together like an amazing little short. Like he put in like me talking, he split in me talking about the Star Chamber, and he's like, if any of you don't know what the Star Chamber is, and he split in the trailer from the Star Chamber. It was so good. And it was up like 15 minutes after the live. He's super talented, man.
All right, wait. So we've got to talk about Dr. G, because I did actually see that question, and I was thinking in my head, wasn't there a question we didn't answer? And I mean, there is definitely some ex parte issues with, well, maybe not necessarily doing the investigation, but yes, if she's talking to just part of the parties about the investigation. But the other half of your question from before, it's also right that a judge is not supposed to be doing like any sort of independent investigation into a case. Like, I'm trying to think of like an example, but it's something else to be like reading, reading the news or seeing on the news that a lawyer has spoken up. So I wish I knew more exactly, unless you do, Bob, of what she's referring to about like the judge doing her own investigation or having conversations without all parties present.
I mean, like, what is the question? Can she do that? No.
She's saying like, how does that not violate some ex parte rule? Like, how is that?
It does violate it. Like her, like, I don't know if like she, like the way she termed it is like, I'm assuming that you're having an investigation into the leaks. Like, I'm assuming, like she said, everything was like, I'm assuming you've already done this. Like, so she was very careful. She carefully words her stuff. Like, so, because it is a problem. Like, you can't do things ex parte. Like, it's a no-no. And I stand by That has to, if there's going to be an investigation into the leak and what happened subsequent to that, with the one gentleman, that has to be investigated, but not by
Aren't they done
anybody.
investigating it? They've already figured out.
I don't know, man. I mean, if they're going to have a hearing, somebody's going to have to investigate it.
Oh, you mean if they're going to?
Creed says, imagine if defense attorneys could remove prosecutors for grossly negligent, unauthorized actions of their employees. Here, Creed. I agree. That'd be great.
Right.
You're out of order. This whole courtroom's out of order. Get out.
You can file a motion to appoint to disqualify a prosecutor and appoint a special prosecutor. I'm sure
I tried to get old Don Klein off. I filed it as a counter to them trying to get you off the case. I was like, oh, this guy's having fireside chats and leaking all the evidence to what's his face, Todd Turdsucker from the Omaha World Herald. Yeah. Ange is another one of our mods. Thank you, Ange. See, I knew I would see people, so I don't think I had thanked Ange. Thank you. You're amazing. You're an amazing human being. Maggie Sosinski, $5 holla. We love you. Thank you.
And somebody said something about Nook, I think.
Who, our puppy, our sweet guy? He's the best.
Who's now banging at the door for me to let him back in. So.
All right. Well, I'm about to let our beautiful European and UK listeners hit the sack because we've kept you up way too long. For all the rest of y'all, we love you so much. Thank you for hanging with us. Thank you for trusting us to give you the straight dope and just facts. We adore you. We really, really do. We're so thankful that you're here. You could be so many other places. There's so many other great shows out there. So we are beyond thankful that you're here hanging out with us. We hope that we make it worth it for you. And just know, I raced back from St. Louis. I drove up there last night, raced from St. Louis. I had I did an interview with Quite Frankly on his show. I'm driving here, raced home, put the computer together, got it set up, blah, 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 blah. So that's how much I love y'all. I was so excited to do this tonight. It was driving me crazy all day not to sit mute on this thing all day because I knew it was out there. My timing was impeccably horrible. So thank you all for criminality. Teresa, what's up, girl? If you're still here, shout outs to all my homies. All right, y'all. Yellow Jacket, what up, girl? The Rockaways, what up? What up? I'm calling it. That's it. So thank y'all. I appreciate you more than you'll ever know because without you guys, I'd just be an old man talking about a new case ish.
Thanks, everybody. Bye, babe.
Just facts. Bye, babe.